Kay Carter was suffering. Her degenerative spinal stenosis was damaging her nerves and life was becoming insufferable. She was determined to leave life on her own terms. She passed alone in secret, without saying goodbye to loved ones, because to die with assistance was illegal in Canada. Gloria Taylor was suffering. Her amyotrophic lateral sclerosis, ALS, was causing irreparable damage to her neurons. Though she was healthy and active when she received her diagnosis, she was told she had 6 months before she became paralyzed and less than a year before she would pass away. She wanted to die on her own terms. Hi, I'm an incoming law student, so please take everything I say with a hefty grain of salt. In this video, we will be discussing the legality of assisted suicide in Canada. Ruling unanimously in favor of Carter, Taylor, and countless other extremely ill Canadians, the Supreme Court of Canada ruled on February 6, 2015, that Canadian adults who are mentally competent and suffering intolerably and enduringly retain the right to a doctor's assistance in dying. This is a landmark case, overturning a 1993 decision in Rodriguez v. British Columbia, which had denied the right to assisted suicide. Prior to 1972, the criminal code prohibited suicide of any kind. Anyone who attempted to take their own life was subject to criminal prosecution. Attempted suicide was a criminal offense. Even if the attempt was unsuccessful, anyone who attempted or aided in attempting suicide could be imprisoned for up to 14 years. In many countries, such as Syria, Papua New Guinea, and Pakistan, suicide is still illegal. However, in 1972, Canada would leave the list of countries criminalizing attempted suicide with Parliament's repeal of the offense from the Criminal Code. Parliament argued that a legal deterrent was unnecessary. It is now a broadly held belief in Canada that those who attempt suicide are in need of medical attention and mental health treatment, not criminal punishment. Suicide rates in Canada have dropped steadily since the 1970s. It is important to discuss that different sectors of society are affected differently by suicide. Regarding Inuit populations, the Globe and Mail writes in 2007, in a population of 30,000 that is mainly Inuit, quote, 40% of deaths investigated by the coroner's office were suicide. Many of the 222 suicide victims were young, Inuit, and male. Nunavut social science researcher Jack Hicks explains that Inuit suicide rates have increased over fourfold between 1984 and 2002. This contrasts the general population, which has experienced a decrease in suicide rates. Regarding Indigenous populations broadly, First Nations, Inuit, and Métis communities experience suicide rates considerably higher than non-Indigenous people across Canada. While suicide rates among active members of the Canadian Forces are approximately 20% lower for males than for males in the general population, former Canadian Forces personnel experience substantially higher suicide rates than their civilian counterparts, with suicide rates between 32% to over 100% greater than non-military personnel. For Canadians aged 15 to 24, suicide is the second most common cause of death. All of this to say that issues regarding suicide and assisted suicide absolutely do not affect everybody equally. There are marginalized groups and vulnerable groups that need to be included in discussions regarding these topics. In the main case of this video, Carter v. Canada, this represents the issue of assisted dying for all of Canada and is thus tremendously important and impactful. In their unanimous decision in favor of victims of dire illness, the court framed the issue as follows. It is a crime in Canada to assist another person in ending her own life. As a result, people who are grievously and irremediably ill cannot seek a physician's assistance in dying and may be condemned to a life of severe and intolerable suffering. A person facing this prospect has two options. She can take her own life prematurely, often by violent or dangerous means, or she can suffer until she dies from natural causes. The choice is cruel. The court determined that the relevant sections of the criminal code should be to, quote, not broadly to preserve life whatever the circumstances, but more specifically to protect vulnerable persons from being induced to commit suicide at a time of weakness. But these sections infringed on rights guaranteed in the Canadian Charter of Rights and Freedoms, specifically Section 7, which protects an individual's autonomy. Stare decisis is a precedent in law that means courts ought to abide by previously ruled decisions and previously existing laws. The interesting thing about Supreme Courts generally is their unique ability and the high frequency with which they do not abide by stare decisis, and instead overturn previous laws or create new precedents for lower courts to abide by. In this court, abiding by stare decisis would mean ruling against Carter, Taylor, and the number of Canadians suffering from dire illness. This is because previous rulings, even in high provincial courts, had ruled that assisted suicide was illegal under the criminal code. However, in this case, the court writes that stare decisis is, quote, not a straitjacket that commends the law to stasis. This was expanded upon in Canada v. Bedford, ruling that trial judges can reconsider decisions ruled by higher courts if there is a new legal issue at bar and if circumstances or evidence have fundamentally shifted the parameters of the debate. Given the unique circumstances of Carter, Taylor, and their peers, it is likely that the judges interpreted dire illness as such unique circumstances or as a novel legal issue for them to resolve. Regarding the changing social circumstances of this case compared to Rodriguez, a case in which the court maintained that assisted suicide was illegal and criminal, have a different, quote, matrix of legislative and social facts to consider. While many celebrated the decision, some characterized it as judicial activism. Judicial activism occurs when judges go beyond their duty to uphold the law and instead venture beyond the present laws to consider the societal impacts of their ruling. Canadian columnist Andrew Coyne went so far as to consider the decision to be the death of judicial restraint in Canada. Judicial restraint is a similar concept to that of judicial activism. It has to do with judges abiding by previously existing and active laws and legislation. To have no judicial restraint is to base ruling decisions on their societal implications with no regard for existing laws. Former politician Stockwell Day was particularly critical of the court, saying, quote, if you want to write laws, you should run for office. However, it is important to note that the decision does have limits regarding physician-assisted suicides. The decision of whether or not to engage in physician-assisted suicide is limited to, quote, a competent adult person who clearly consents to the termination of life and has a grievous and irremediable medical condition, including an illness, disease, or disability that causes enduring suffering that is intolerable to the individual in the circumstances of his or her condition. Even some medical branches were not exactly celebratory in their response to the decision. The Canadian Medical Association, CMA, reported that not all doctors were willing to help a patient die. However, the belief in late 2015 was that no physician would be forced to do so, but the CMA was offering educational sessions to members as to the process that would be used. The court decision includes a requirement that there must be stringent limits that are, quote, scrupulously monitored. This will require the death certificate to be completed by an independent medical examiner, not the treating physician, to ensure the accuracy of reporting the cause of death. Following a delay of over a year, the House of Commons passed a bill, C-14, in mid-June 2016 that would allow for doctor-assisted suicide in the case of a terminal illness. The bill was then debated in the Senate. Initially, the Senate amended the bill, expanding the right to die. However, when it became apparent that the elected House of Commons would not accept the amendment, a final vote was held on the 17th of June 2016. At that time, a majority agreed with the restrictive wording provided by the House of Commons indicating that, quote, Only patients suffering from incurable illness whose natural death is reasonably foreseeable are eligible for a medically assisted death, as summarized by the Toronto Star. Critics of the bill indicate that the Carter decision was broader, including desperately ill individuals and not only those who are terminally ill or near death. This is an interesting case of the legislative branch not exactly abiding by a ruling made by the judicial branch. What if, for instance, someone whose death is not reasonably foreseeable but is suffering indefinitely wanted to engage in assisted suicide? This would be illegal according to Bill C-14, but is in line with the Supreme Court's ruling. It is likely that further amendments will have to be made to the bill as such cases arise. What are your thoughts on this issue? Do you agree with the Supreme Court's ruling? Thanks for watching.